Hi, my name is Paul Horn. I am a California estate planning attorney. I'm also a CPA. So my firm, all we do are living trust and probate. I do not do immigration, divorces, criminal law. This is my specialty. Okay, and we're going to talk about estate planning today. Um, give you a little bit background on who I am. I'm married. I live in Southern California. I have two beautiful children. It's my son there. He's 4 years old. My daughter's 6 years old. And yeah, it's my beautiful wife in the background. So let's get into it. This cartoon, the receptionist is saying, hey, you have two appointments, you have two visitors. One is death, one is tax. They're here to see you. It's death and taxes to see you. Taxes wants to come in first, right? It's just it's a funny cartoon, but it's true, right? Death is going to come, and it's the unfortunate reality of life. Death is undefeated, right? 100% everybody die. So look, estate planning is important. You got to get yourself in estate planning. And the goal of estate planning is to give what you have to whom you want, the way you want, and when you want it. Okay, so that's the goal of your trust. And also the goal of your estate planning is, hey, if you have dementia, Alzheimer's, you're frail, you're weak, you don't know what's going on, is there legal documentation in here to allow your husband, your wife, your son, your daughter to take care of you? And your trust, your estate planning should care for your surviving spouse, your children, AKA we don't want your minor children to be in foster care. So that's why it has to be proper estate planning. Distribution issue, meaning when you pass away, we don't want children fighting over the houses and your cash. If you have charitable intention, we can put that in the trust and pass on your value and idea to your children, your grandchildren, and also at the same time to maximize all the asset that goes to your children, to your loved one, and at the same time protect it because, for example, when it goes to your children, divorces are huge, lawsuits on your children will protect your children from those elements. Okay. So a comprehensive estate planning is what you need. And what is in this binder, in your estate planning binder, you'll get this book. It ought to have the trust as the main document, followed by a will, a pourable will, where it says, hey, I have minor children. If something happened to me, I wish so-and-so should be the guardian. Okay, everything I own should go to my trust. That's called a pourable will. You'll also get an advanced healthcare directive that's going to be in here. Should you become, if you're at the hospital, you're unable to speak or talk, the hospital is going to ask for the advanced healthcare directive that's going to give your loved one the legal authority to speak on your behalf for healthcare services. The durable power of attorney, you're over 18. If you're unable to sign for yourself, the durable power of attorney designate who can sign on your behalf. And then you'll get a living will. We'll talk more about that. You're going to get a HIP authorization. You're going to get a personal property memorandum, an assignment of all your personal property into your trust. And you're going to get a certificate of trust, a trust ID, and brand new grant deed that shows that your trust owns the house. Okay, so yeah, so you'll get a binder like this along with a electronic copy. So what is a revocable living trust? So a revocable living trust is a private document between you and the trustee. So in California, when you create a living trust, you are the grantor and the trustee at the same time. You own everything in your trust. We will transfer the house into the trust, the bank account into the trust. Your trust owns all the assets. As long as you're alive, you are in charge. You can use it, you can sell the house, you can refinance the house. After you pass away, then whatever's left in here, asset-wise, goes to your children, okay? And as long as you're alive, you're able to change this estate planning, change your trust. Now, what asset goes into your revocable living trust? Well, it's going to be your real estate, your primary house, your rental property, all cash, stocks, bonds, investments, retirement account, goes into your trust, right? It's got to have a place that's going to say upon my death, then it goes to my loved one, my children, my niece and nephew, brother, mom or dad, or so forth. Okay, it goes to them tax-free. The house that you bought for $200,000 now it's worth $1 million. It will be tax-free, okay, because it's in a trust. Okay, now revocable living trust. When you create a revocable living trust, you are the maker, you are the grantor, and also you're going to be the trustee as well. So we put all the asset in here. We put your house in the trust. We change the ownership of the house to be owned by the trust, but you would be the initial trustee. You would be in charge of this trust. So that means that you can sell the house, refinance the house. In this trust, we'll also say, hey, if I become incapacitated, so-and-so will be the trustee to use all this asset to take care of me. There'll also be a death trustee, meaning, hey, while I'm alive, I'm in charge. Upon my passing, yes, the property goes to so-and-so, but I choose someone to be in charge. That's called your successor trustee, your death trustee, okay? And also, when the asset goes to your children, it's going to go into an inheritance trust, protected, so there'll be a trustee for that inheritance trust as well. All right, so revocable living trust, okay, is very valuable, okay, because it's a lot of privacy involved. All your asset in here, who are the beneficiary, everything is private. So a trust is critical, because if you don't have a trust, you can end up in probate, and probate is a very public process. People's gonna see what you own, who are your family, okay? It's not a good setup. For example, you don't want your daughter who's getting $4 million to have the whole world know that, for example, okay? And the other important thing is medical recovery. If you have a trust, there will be no medical recovery, okay? Huge, right? So once you get older, you use medical, but if you have a trust, there'll be no medical recovery. Why? Because there'll be no probate, okay? All right, so let's talk about distribution going to your children. So while you're alive, you own everything. Once you pass away, it's going to go to your children, for example. It can go to them in various manners. It can go to them, one, outright, or two, in different stages. For example, age 25, 25%, age 25, for example, 1/3, 30 years old, another 1/3, maybe 35, the rest. And these are arbitrary ages that you get to pick, okay? Or you can do another option where it goes into an inheritance trust, where it stays there for your children's benefit, and it stays there to protect it against lawsuits, divorces, and so forth, okay? So the example is this. Let's say you have 3 children, right? You have son Bob, your daughter Mary, your son Jim, and let's say Bob is a medical doctor, working professional, entrepreneur, and all your asset goes to these 3, a third, you love them very much. But if they have various problems, it's going to be all gone, right? Let's say Bob, who's a doctor, he gets to a divorce, or your daughter Mary, who's poor financial decision, gets a divorce, or your son, let's say Jim, for example, creditors problem, bankruptcy, it will be all gone if you left it in a trust that goes directly to them with no specific protection. So then the question is, okay, so you put everything in a trust, that's great, good. You're going to avoid probate, great. But will your trust protect your beneficiary, right? So we talked about giving to them outright. It's probably not a great idea, right? And your children may be too young, too elderly, ill, disabled, or struggle with drug addiction, alcohol, and so forth. Not good at handling finance, having issue with creditors, or maybe they're receiving some sort of governmental benefits. There are special needs children, autism, disability, and so forth, because if once you pass away, your asset goes to one child, and that one child is receiving some sort of governmental benefits, it's going to make that child disqualified from the governmental benefits. That we can protect as well. Okay. All right. Yeah. And let's say if the situation changed, the trust would morph with it to protect your children. So the solution is, hey, once you pass away, the asset goes to your children. Let's put it into an inheritance trust, meaning it's protected in a vote against divorces, lawsuits, and so forth, right? So we're saying, even if your children are perfect, they handle money perfectly, right? So even if none of those problems exist, outright distribution may still be wrong for your family. Your beneficiary may be capable of handling money, but what about the spouse taking the inheritance or forcing them to be spent? Bad luck, creditors, bankruptcy, lawsuit, whether it's valid or bogus, right? And we talked about the governmental benefit, the government forcing them, hey, use up your mom and dad's money first, then come back for your medical benefits, for your medical insurance, and so forth. Okay, so a good trust really ought to embody your legacy, right? How do you want to be remembered? Do you want to have charitable giving in your trust? What value do you want to pass on to your children? Okay, so that's the trust. So in this binder that you get the trust, what we talked about, where it passes your asset to your children in a protected manner, avoids probate, and they do not need to pay taxes on the house that you bought for 400,000. House worth 5 million. Okay. The next thing you need that's in here is a separate legal document known as a durable power of attorney. And a durable power of attorney says, hey, if I become incapacitated, my son, my daughter, my wife, my husband can sign on my behalf for financial decision. If you have a stroke, if you have dementia, Alzheimer's, your daughter can sign your name and take care of you. That's called a durable power of attorney. Now, a durable power of attorney is important because it will avoid conservatorship. You don't want conservatorship. If you have dementia, Alzheimer's, and you don't have an estate planning in place, your son, your daughter, your wife, your husband has got to go to court and says, hey, judge, put me in charge of my husband, my wife, my mom, my dad to be the conservator. It's a very public process, supervised by the courts. It's embarrassing. You don't want to do conservatorship. So make sure your estate planning, in addition to the trust, has a durable power of attorney to avoid conservatorship. Now, this binder should also have an advanced healthcare directive, okay? If you're in the hospital, you're not able to speak or talk, you're at the doctor, you cannot speak, you cannot talk, the advanced healthcare directive designated individual, your son, your husband, your daughter, to speak on your behalf. It's very important because the hospital, because you cannot speak at that moment, they don't want to be sued. So they're going to say, hey, legally, do you have in your estate planning, a separate document? So right, we talked about having a trust in here, having a durable power of attorney. The third one would be an advanced healthcare directive that says, hey, hospital, you can speak to my son, my daughter, my husband, my wife. I designate them to speak on my behalf. Okay, yeah. You also going to get a HIPAA authorization. That's important because healthcare information are private, right? So your doctor, the hospital is only going to release medical information to you. But there are certain situations where you do want your loved one to be able to access your medical record, bring it to a specialist to save your life. And that should also be part of your estate planning, a HIPAA authorization. There's also something called a living will. So a living will, it says, hey, if I'm a permanent vegetable, right? If I'm in a permanent vegetative state, it's irreversible, it's terminal. Please don't argue in court, don't fight in court to keep me on the machine forever. Okay, so that prevents fights in court that's going to drain the estate money. And then you separately in this binder, you also get a will. It's a special type of will. It's called a pourable will. That says that everything we own pours into the trust for our children, for our loved one. Okay. So now, who needs an estate planning? Well, everyone does, right? So in California, you may be shocked that if you don't do your own estate planning, who gets what? the state of California has one for you. Okay, so if you pass away with your house, your asset, if you don't have an estate planning, it goes to probate, it goes to court, and California law takes over and says who gets what. Okay, all right. Now, beware of the bare bone trusts, meaning trusts that are not tailored to your specific family. Okay, be careful of trust that is off the shelf, off the internet. Don't do them, because you're going to be, your children's going to be shocked that, hey, this doesn't work. Okay, so in our firm, in my law office, we have a 5-step estate planning process. So the first thing is we meet with you, learn about, your family, your asset, your objective, whether you have a special needs child, whether your children are great, how do you want to pass on your asset to them. So we talk, we meet, and then step 2, we design the trust, we draft the trust, we call you, we address other concerns that you didn't think about. Okay, so that's part 2, the drafting, the communication to get it right. And in step 3, when it's done, we invite you into our office to sign this binder, where we go over all the documents to make sure everything is correct, spelled correctly, the name and so forth. And then number 4, we will record the grand deed for you. Your house will be part of the trust. We will take that to the county assessor to record it for you. Step 5, we get you back the grand deed so you can put it back into your trust, make sure everything is done. And all this is done within 2 weeks, within a 2 weeks time period. Okay. All right. Finding the right attorney. Finding the right attorney to do your trust is very important. What you want to ask is the attorney primary practice estate planning? That's critical, right? And the next question is this attorney state bar certified specialist? Because less than 1% of all attorneys in California are state bar specialists, okay? And how do you know if they're a state bar specialist? The state of California has given them this logo. This logo is meant to help the public like yourself to distinguish their professional from the amateur, okay? Because to be a certified specialist, you gotta have a certain amount of experience, ethics, pass a certain amount of exam, okay? So all these comes together, the state bar. Once you have all these criteria, then they'll issue you this logo that you are a specialist, okay? And then also look at the attorney's reputation and review on Google, on Yelp, okay? If you look at my firm review, we have 5-star across the board. And so, yeah, so I look forward to meeting with you. This video is meant to give you sort of a preamble as an appetizer to what is estate planning, what does it involve. Call my office. We're in Cerritos. The number is 562-474-1231. Thank you.